Court is back in session. You may be seated.
All right, I believe there are two matters I need to take up outside the presence of the jury.
Does Your Honor want Mr. Daniels here or at the witness stand?
Witness stand. Actually, just at the podium will be sufficient. I'm sorry. All right, Mr. Daniel, if you'll raise your right hand, let's place you under oath.
Do you solemnly swear affirm testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Mr. Mitchell?
Mr. Daniels, you and I went over this waiver, correct?
Yes.
And we've talked about your right to testify,
Yes.
your right not to testify.
Yes.
We've discussed the benefits and why you would and would not testify.
Yes.
And you're making this decision to not testify voluntarily and of your own free will.
That's correct.
This is your signature?
Yes, sir.
All right. Your Honor, if I could hand it
Mitchell, if
forward.
you'll pass that to the bailiff. Mr. Daniels, I just want to make sure that you understand that you have a right, absolute right to testify if you choose to do so in your own behalf at your trial. But you also have a constitutional right not to testify, and there will be no inference given to the jury. Then they'll be instructed they're not to infer anything from the fact that you don't testify. Do you understand that?
Yes, sir.
Do you also understand that if you want to testify, no one can stop you from it?
Yes, sir.
And it's my understanding that you are choosing, after consulting with your lawyer and weighing the risks and the pros and cons, that you have considered the issue and that you have decided you do not wish to testify. Is
That's
that
correct.
Is this done voluntarily?
Yes, sir.
Anyone forcing you to do this?
No, sir.
All right. Thank you, sir. Then you may have a seat. We'll show that the defendant has waived his right to testify at his trial. Is there anything then we need to take up? I believe you have a motion for judgment of acquittal. Is that correct?
Yes, Your Honor. Two aspects. One, we maintain the state has not shown venue in Dixon County. And two, I'm not going to argue all the facts. Your Honor's heard all the testimony.
Thank you. The motion for judgment of acquittal is a requirement that rules of criminal procedure apply, and Mr. Lockhart's a very experienced lawyer, and I have considered and weighed all of the proof and found that the testimony has risen to the level where a reasonable juror could conclude that the state has met its burden of proof beyond a reasonable doubt as to all of the elements of the crime, and therefore the motion for judgment of acquittal is respectfully denied. I also found that there's been evidence regarding the venue of this action, which is, according to this court's memory, has been sufficiently established for the jury, but although that will be a fact issue, they're instructed in the original case as well, in the original charge as well as in the court's instructions will be that they are to consider the venue issue. Any other matters then before we begin? Is the defense going to put on proof as well?
No, Your Honor.
No other proof? All right, then we are ready for closing arguments. Is that correct? Are you not calling any other witnesses?
That's not the judgment. I think Mr. Lockhart and I have spoken with you all correctly about some other issues.
We could have a couple of hours.
Well, let me do this. We're working on the final charge, which I just reviewed in the last break, and that will be a matter of want you to look over and make sure that you have any other requests or any other exceptions to our charge, and then I'll give you that time to prepare yourself for closing arguments. But what I'd like to do is to bring the jury and explain to them that there's going to be at least a couple of hour delay in this, and give them the opportunity to understand that the proof has been closed and that they're going to be hearing only. I was handed a question, and I'll address that with the jury. The jurors asked a question. Steve Kennard's testimony was interrupted with the intention that he was going to be recalled. This is on Saturday with the intention he was going to be recalled. Does Mr. Kennard need to be recalled? I think they misunderstood. Agent Kennard was called to the Delcu case in Nashville to testify on Monday, and that's the reason that both sides agreed not to ask any further questions of Agent Kennard, if I recall correctly. Is that right?
Yes, Your Honor, and the fact that interview was also witnessed, and there were people within it that were speaking, particularly Trevor Daniels, and there were questions asked of him about that particular interview.
All right. Then what I will do is when I bring the jury back in to instruct them that the case has now been concluded, I will explain to them this portion of that unless there's some other issue. Bring the jury in.
Your Honor, will you approach?
You may. Ladies and gentlemen, you may be seated. Thank you. Let me address you on a couple of points so that you understand. At this point, the evidence in this case has been concluded, and the state has rested their case, and the defendant has advised that they do not wish to put on any proof. There are a couple of things I want to explain to you. I was handed a jury question that states as follows. Steve Kennard's testimony was interrupted on Saturday with the intention he was going to be recalled. Does Mr. Kennard need to be recalled? First, I think that's perhaps I didn't make that clear. Agent Kennard testified, and after we finished with the video, he had to be in another court on Monday when we were adjourning that day at noon, and it was agreed by both sides that neither side intended to ask him any additional questions because there were other people present during that video interview and that they could be questioned about that video interview. So he was released from his subpoena with no intention of recalling him to bring him back. So that answers your first question. The second question, one of you had requested, would it be possible to be driven around the area of Garnish Creek, Harris Road to Love's Truck Stop and over to McElhaney for situational awareness? And that's a good question. There is some limited authority in the state of Tennessee to allow such a thing if the situation rises to the level where there is some mass confusion about it, or if there's been insufficient demonstration to the jury of the actual geographic locations and so forth. It is this court's opinion that taking you out and showing you and driving you around that area would be more confusing perhaps to you and would be more time consuming security-wise and otherwise, and that ample evidence has been introduced in this case with graphs, photographs, and charts that have been shown and pointed out to you that would be sufficient to allow you to do that. So with that, I need to advise you that my assistant has been working on our final charge to you, that charge that I told you I was going to give you and give you your own copy to follow along. There are 41 pages in that charge right now, which means that if you didn't have your own copy, you're going to sit here and listen to me read through 41 pages and try to understand it. So you're going to have your own copy. It'll take us a little while to do that. Both of the lawyers will be entitled to have a copy of that to prepare for their closing argument. And they've asked for a couple of hours to think through and to try to prepare their closing argument. I think that is reasonable. Unfortunately, I know it means that you're going to be cooling your heels for a couple of hours while we allow that to be done. But this is a necessary step because the next step is they're going to make their closing argument. I will then read you that charge with you reading along with me, and you will retire to deliberate. After I've charged you, I will then randomly select 4 of you who will be designated as our alternates. And those 4 people will get to go home today, or at least as soon as we finish with charging the jury and you begin your deliberations, because only 12 people will decide this case. We've had 4 of you all along in case there was some sort of an emergency. Those 4 can stop along the way and buy a lottery ticket if they want to because of the simple fact that they were lucky enough to be out of this draw. But under the circumstances, you are going to have to wait and see who is going to be that person. So all of you have to pay attention to us when those closing arguments are made and when that final charge is read, so that you will be prepared to begin your deliberations without knowing whether you're an alternate or not. So I apologize for the delay that's going to be occasioned, but it is a necessary step in the next process to try to conclude this case. Thank you for your patience. You've been great as far as helping us to get through this trial on a quick basis. I apologize for all the times I've had to run you in and out, but if you will step back one more time, then we'll try to get this case ready to take to the jury. All right. All right, it is currently 3:15 or 20 till 3, and if my understanding is you would both like a couple of hours, is that right?
Motion followed for special jury instructions.
That's part of this time period.
Well, let me go ahead and address that if you'd like now, although I left my, no, I have it, I think, here.
I need to read the jury charge that we have.
We'll take it up at the appropriate time. After you've read the charge, we're going to get it ready, then we'll read it and then let you read the charge, and then I'll consider any argument you make for an additional change to it. So. All right, we'll stand in recess. I anticipate it being 4:45. Is that correct? Any way you could be ready by 4:30?
We haven't read the instruction at all.
You what?
We haven't read the instruction at all.
All right.
And the proof is just so voluminous. I think both sides need some time to tie everything together, because
Well, here's the next question. Would you rather just adjourn for the day and come back tomorrow at that point?
Judge, we need that time.
That would be-
I don't even know the exhibit numbers. I mean, there's over 200.
Over 200 exhibits, is that what you're saying?
Yes.
It's actually 259. If you'd like to know the exact number, so.
There you go. That's why we need more time. How do you close?
Well, I think that's appropriate. This is a complicated case, and there are a lot of there's a lot of moving parts and a lot of evidence, and I want both sides to feel like they've been given a fair opportunity to review our instructions. So, I will have what I'd like to do is discharge the jury and let them go on back to where they're staying. Let you see a copy of this charge once Ms. Fry has it finished, and then I will consider your request for any changes before you leave today, so when you leave here, you know what you're going to be dealing with in the final charge. Is that fair enough? All right, then I'll just, with everyone's consent, I'm just going to step back and tell the jury that rather than start deliberations at 6 o'clock tonight, we're going to start them at 9 o'clock in the morning.
that's fine.
You know, one more matter for the record. We have to substitute exhibits 11 and 17. There were some redactions that were required in court. Future copies substituted. I made this. Mr. Mitchell, we agree to that.
All right, show that those will be substituted. Then we'll stand adjourned. I said 9 o'clock. Any reason we can't again start with the closing arguments at 8 o'clock in the morning?
That's fine.
8 o'clock in the morning for
I'm
closing
kinda used to
arguments.
it. I think all the lawyers made us want to
Get a
do
lot
8
more
o'clock from now on.
accomplished. Get a lot more accomplished when you start that early, don't you?
All rise.
Recording stopped.
This court is adjourned.
See you in the morning, Joe. Yep.